आज के इस वीडियो लेक्चर में हम दिल्ली जुडिशियल सर्विस एग्जामिनेशन 2022 का पार्ट सेकंड डिस्कस करेंगे। यानी हमने 100 क्वेश्चन डिस्कस कर लिए थे, बाकी के 100 आज के इस वीडियो में हम देखेंगे। तो स्टार्ट करते हैं। हमारा 101 नंबर का जो क्वेश्चन है वो है एन ऑर्डर टू पे मंथली अलाउंस for the maintenance under section 125 of the code in favor of a married woman and against her husband may be cancelled if she has obtained divorce and thereafter remarried, she has been divorced by the husband and has received whole of such sum which under the customary or personal law was payable by the husband on such a divorce. She has obtained divorce from the husband surrendering her right to maintenance after divorce, all of the above. तो इसके लिए आपको देखना है CRPC जो है हमारा उसका सेक्शन 127(3) ये आप देखोगे तो वहाँ पे आपको ये सारी चीज़ें मिल जाएंगी और ऑल ऑफ द अबव यहाँ पे आंसर होगा। Next question 102. An inquiry into the cause of death must be held in a case where the death has occurred before the person after arrest could be produced before a magistrate by district magistrate only, judicial magistrate in addition to inquiry by the police, nearest executive magistrate, none of the above. तो इसके लिए आपको देखना है 176 सेक्शन CRPC का। तो वहाँ पे देखेंगे तो लिखा हुआ है वहाँ पे जुडिशियल मजिस्ट्रेट इन एडिशन टू इंक्वायरी बाय द पुलिस। नेक्स्ट क्वेश्चन है A and 4 of his accomplices who absconded are alleged to have kidnapped Z from New Delhi and taking and confining her in several places at Gurgaon in Haryana, from where ransom calls are made and then taken to Uttar Pradesh. After a week, her dead body bearing multiple ante-mortem stab wounds is found at secluded spot in Kanpur. Cases are registered by police in New Delhi, Gurgaon and Kanpur. A is arrested by Kanpur police and interrogated, leading to recovery of weapon of offense. Upon his disclosure, the personal article of G are recovered from the place of her confinement in Gurgaon. The evidence is shared by the police in each state with their counterpart in other two states. Report of investigation on such basis under section 173 of the code are filed by police seeking trial of AN on charge from the offense of kidnapping for ransom and murder in Kanpur, Gurgaon and New Delhi. In that order, cognizance on each such report having been taken by the jurisdictional magistrate summoning A as accused. Options हैं the High Court of Judicature at Allahabad shall decide as to court at which place will inquire into or try the offence. Second है the High Court of Punjab and Haryana shall decide as the court of which place will inquire into try the offence. Third one is the High Court of Delhi shall decide as the court at which place will inquire into or try the offence. And D है only the court of New Delhi can inquire into or try the offence since that is the place from where the kidnapping took place. तो इसके लिए आपको देखना है CRPC का सेक्शन 186। सेक्शन 186 जो है उसमें आपको मिल जाएगा ये 186 में दिया गया है कि where two or more courts have taken cognizance of the same offence and a question arises as to which of them ought to inquire into the try that offence, the question shall be decided. तो A है if the courts are subordinate to the same high court by the high court, and second है if the courts are not subordinate to the same high court by the high court within the local limit of whose appellate criminal jurisdiction the proceedings were first commenced, and thereupon all other proceedings in respect of that offence shall be discontinued. तो आंसर है यहाँ पे A. नेक्स्ट क्वेश्चन है ए कंप्लेंट इज प्रीफर्ड बाय एन एग्जीक्यूटिव मजिस्ट्रेट एलिजिंग दैट ए वर्किंग एज एन ओथ कमिश्नर समन्ड as a witness to produce the record of affidavit attested by him in an inquiry into dispute as to possession of an immovable property intentionally filed to appear or produce the record. A is summoned as accused and after trial is held guilty at the stage of appeal. The offence may be lawfully compounded. The complaint may be lawfully withdrawn by the district magistrate to whom the complaint is administratively subordinate. Both of the above and none of the above. तो यहाँ पे आंसर होगा none of the above. अगला क्वेश्चन है, नो कोर्ट कैन टेक कॉग्निजेंस ऑफ द ऑफेंस ऑफ एडल्टरी except on the complaint made by the wife only, the husband only, the wife or a person responsible for her care in his absence, the husband or a person responsible for her care in his absence. So here is answer is D. एंड इसके लिए आपको डिटेल में देखना है 198 सेक्शन क्रिमिनल प्रोसीजर का, वहाँ पे गिवन है. 106. Upon perusal of a complaint alleging offense of cheating and dishonestly inducing delivery of property during the course of business transaction between two firms, the jurisdictional magistrate may take cognizance and examine upon oath the complaint and the witness who are present. Examine upon oath the complaint and the witness who are present, and then consider if cognizance be taken or not. Decline to take cognizance if the offense alleged is triable exclusively by the court of session, and issue summons to the accused if prima facie satisfied on basis of affidavit of the complaint, and then examine the complaint and his witness in the presence of the accused. तो 106 में आएगा. इसके लिए सेक्शन नंबर 200 देखना है क्रिमिनल प्रोसीजर का, उसमें दिया गया है, टेक कॉग्निजेंस एंड एग्जामिन अपॉन ऑथ द कंप्लेंट एंड द विटनेस हु आर प्रेजेंट. नेक्स्ट है, A is charged with the offense of voluntarily causing grievous hurt by use of dangerous weapon under section 326 of IPC. The prosecution fails to prove that there was any dangerous weapon used. The accused shows by defense evidence that he had acted on grave and sudden provocation. Then he may be guilty for offense of voluntarily causing grievous hurt on provocation under section 335 IPC even though no charge for the said offense has been framed. ए इसमें आंसर होगा. इसके लिए आपको 216 जो सेक्शन है वो देखना है CRPC का. अगला क्वेश्चन है कि ड्यूरिंग द ट्रायल ऑफ ए केस इन्वॉल्विंग एक्यूजेशन ऑफ मेडिकल नेग्लिजेंस having resulted in death of a human being, after having recorded the evidence of the complaint and some other witnesses, the criminal court is of the view that the offense should have been tried in accordance with procedure for trial of a warrant case. तो इसके लिए देखना है 259 of criminal procedure code, and here answer is that the court may convert the case into warrant case but must first frame a formal charge, and after recording plea of the accused take evidence for the prosecution and the witness earlier examined. 109. Under the provision for plea bargaining in the code in a case instituted otherwise than on police report, the mutually satisfactory disposition is a matter exclusively between the complaint on one hand and the accused on the latter. Then what is the answer? Here is the answer is the above statement is incorrect, since victim is entitled to be called and the participate in the meeting convened for the purpose. For this 265 C ये देखना है CRPC का. Next है, where upon an application of the accused for plea bargaining, a satisfactory disposition of the case has been worked out in accordance with law, the court must award compensation whether or not agreed upon the parties. 265 E देखना है इसके लिए. Next है 111. In a trial on the charge of attempt to rape at the stage of recording of the evidence of the 16-year-old prosecutrix, the accused insists on being present and be allowed to himself confront her by showing to her some video footage on his mobile phone. So the request of the accused may be declined. The court must adopt appropriate measure to ensure that it is no direct confrontation between the accused and the prosecutrix, and the right of cross examination is effectively exercised. इसके लिए 273 देखना है सीआरपीसी का. Next है the evidence of a witness from Kerala given in Malayalam in the course of trial of a criminal case in Delhi is taken down in the said language with the help of a translator and a member of staff of the court acquainted with the language. The presiding judge is also from Kerala and knows the language. Referring to this background, he dispenses with the requirement of translation of the disposition in the language of the court to be prepared. The order of the presiding judge is incorrect since it is mandatory for such transaction to be prepared. For this 277 CRPC पढ़ेंगे. जो दिल्ली जुडिशल सर्विस के एग्ज़ाम है ये अदर स्टेट के एग्ज़ाम की तुलना में थोड़ा टफ होता है क्योंकि ये फर्स्ट चॉइस होता है ज़्यादातर जो स्टूडेंट्स हैं उनकी, तो प्रायोरिटी पे इसको रखते हैं, इस वजह से ये कंपैरेटिवली टफ है. 113. A is tried for causing grievous hurt to V and convicted. After the completion of the trial, V dies as a consequence of the injuries suffered. The state now wants to prosecute A on charge of culpable homicide. तो इसके लिए आंसर होगा it is permissible because the consequence of the act committed had not happened at the time A was convicted. 300 जो है सीआरपीसी का उसमें एक इलस्ट्रेशन ऐसा दे रखा है. In a criminal trial, an accused may be examined as a witness in his defense but only on his own request in writing. तो ये दिया है 315 एक में CRPC. Next है when during committee proceedings a magistrate after holding an inquiry find that the accused is of unsound mind and consequently incapable of making any defense. तो ऑप्शंस दिए हैं यहाँ पे, क्या होगा आंसर? आंसर होगा बी. He shall postpone further proceeding in the case but may resume it after the person has ceased to be unsound mind. नेक्स्ट है इसके लिए 331 सी देख सकते हैं सीआरपीसी का. अगला है इफ़ द क्रिमिनल कोर्ट आफ्टर ट्रायल हैविंग convicted the accused impose a sentence of which fine forms a part, then it may direct the fine to be applied in payment of compensation to the person who suffered loss on account of the offense and also recommend payment of further compensation from out of funds of victim compensation scheme to make it adequate. So it is given in 357 1 of CRPC. Next है a criminal court after convicting on charge of assault proceeds to award the punishment to the accused, a 30-year-old man with no previous criminal record, refusing to hear the defense on plea of release on probation of good conduct. Then the approach is impermissible since it is incumbent to consider such plea and if not allowed, special reason must be recorded. 361 देखना है इसके लिए सीआरपीसी का. एक 118 when a person already undergoing a sentence of imprisonment is sentenced on a subsequent conviction to imprisonment, then such imprisonment shall commence at the expiration of the imprisonment to which he was previously sentenced. 427 1 of CRPC. A is charged with the murder of Ajay on 21/1/2021. In fact, the name of victim was Ajay. An offence was committed on 20/1/2021. The evidence adduced by prosecution correctly mentioned the name of the victim and the date of offence, and he cross-examined the witness accordingly. The trial ends in conviction. The error is inconsequential and accused was not thereby misled. The rules framed by the central government in exercise of the power conferred by the Army Act 1950 permit court martial of an army personnel for an offence committed against a civilian while on leave or absence from his unit in a civil area. If such an army personnel is arrested and brought before the metropolitan magistrate and his prosecution is sought by the state on the basis of charge sheet filed by the state police, but the commanding officer of the unit to which the accused belongs moves an application in writing seeking transfer of the case and the accused for purpose of trial by a court martial, then it is lawful for the metropolitan magistrate to deliver the custody of the individual to the commanding officer and make over the case for court martial. 457 1 of CRPC talks about it. A who are previously convicted for the offense of rape with sexual intent touch the vagina of B aged 17 years under the protection of children from sexual offense act 2012. A has committed the offense of सेक्सुअल असॉल्ट. इसके लिए सेक्शन 7 देखना है प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंस एक्ट का. अगला है ए विद सेक्सुअल इंटेंट मेक्स बी ए बॉय ऑफ 12 ईयर रिमूव हिज अंडरवियर टू एक्सहिबिट हिज प्राइवेट पार्ट्स टू दैट ए कैन सी द सेम अंडर द प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंस एक्ट 2012. ए हैज कमिटेड द ऑफेंस ऑफ सेक्सुअल हरेसमेंट. सेक्शन 11 देखना है इसके लिए प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंस एक्ट. नेक्स्ट क्वेश्चन है अंडर द प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंस एक्ट 2012 इन केस द पेरेंट ऑफ द चाइल्ड विक्टिम और एनी अदर पर्सन इन whom the child victim reports trust or confidence cannot be present for the medical examination of the child victim. The medical examination has to be conducted in the presence of a woman nominated by the head of the medical institution. सेक्शन 27 देखना है इसके लिए प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंस का. Next है the special court after taking cognizance of the offence under the protection of children from sexual offence act 2012 has to record the evidence of a child victim within 30 days. It is given in section 35 of this act. Next question is under section 14 of the protection of children from sexual offense act 2012 whoever uses a child for pornographic purpose shall be punished with imprisonment for a term which shall not be less than 5 years. इसके लिए section 14 1 देखना है. नेक्स्ट क्वेश्चन है सेक्शन 75 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट इज एप्लीकेबल ऑन. तो ये रिलेटेड है सब्सिक्वेंटली वॉइडेबल कॉन्ट्रैक्ट से लेके. अगला है एन एग्जीक्यूटेड कंसिडरेशन इज एन एग्जीक्यूटेड कंसिडरेशन इज एन एक्ट इन रिस्पॉन्स टू ए पॉजिटिव promise. The principle relating to responsibility of finder of goods has been laid down under इंडियन कॉन्ट्रैक्ट एक्ट के सेक्शन नंबर 71 में. द नेचर ऑफ ए वेगरिंग एग्रीमेंट वॉज एक्सप्लेन्ड इन द केस ऑफ कार्लिल वर्सेस कार्बोलिक स्मोक बॉल कॉरपोरेशन. अगला है of the Indian Contract Act 1872 prescribe that the acceptance must be made in a reasonable manner. If the proposer has prescribed a manner of acceptance, the acceptance must be made in that manner. If not so made, there is a contract only if the proposer accepts the acceptance. 7(2) में गिवन है ये कॉन्ट्रैक्ट एक्ट में. नेक्स्ट है which describe a voidable contract as one which is enforceable by the law at the option of that parties but not at the option of the others. Section 2I of the Indian Contract Act. When there is a duty to speak उस टाइम में साइलेंस से रहना कहलाएगा फ्रॉड. इसके लिए 17 देखना है सेक्शन इंडियन कॉन्ट्रैक्ट एक्ट का। ए promise to pay a time bar debate is enforceable if some condition are fulfilled. Which of the following condition is not required? It must be registered is not required. 25 देखना है इसके लिए ICA का। Resident in India for the specific purpose of being a designated partner under the Limited Liability Partnership Act 2008 requires minimum residency stay in India for how many days during one immediately preceding year? 182 days. Which of the following is not a circumstance in which a limited liability partnership may be wound up? When the number of partners is reduced to below 2 or 3 consecutive months. So this is not a circumstance. Which of the following circumstance is not one where a partner of an LLP will cease to be a partner if he has been convicted for an offense by a competent court? Which amongst the following is an arbitral dispute under the Arbitration Act 1996? इसका आंसर होगा C. Landlord and tenant dispute arising from a lease deed covered under the Transfer of Property Act 1882. Next, in an arbitral tribunal consisting of 3 members, an interim order of restraint is passing, staying the invocation of a bank guarantee. Subsequently, for health reason, on one of them withdrew from the office of the arbitrator, and a substitute arbitrator is appointed by the court. Now that the composition of the arbitral tribunal has changed, what is the legal effect of the restraint order passed by the erstwhile tribunal? Still valid, as the change of composition of the tribunal does not invalidate the order of the erstwhile tribunal. तो ये आर्बिट्रेशन एक्ट के हैं, इसलिए इनको डिटेल में नहीं देख रहे हैं क्योंकि सब एग्जाम के लिए इम्पोर्टेंट नहीं है ये। नेक्स्ट, विच अमॉन्ग द फॉलोइंग इज नॉट एन अपीलेबल ऑर्डर अंडर द आर्बिट्रेशन एंड कंसिलिएशन एक्ट 1996? इसका आंसर होगा डी, रिजेक्टिंग द प्ले अंडर सबसेक्शन 2 ऑफ सेक्शन 16। 140 में है मिस्टर ABC, an Indian, enters into a contract in Mumbai with Mr. PQR, an American who is in India on a business tour. The agreement between them contains an arbitration clause which states that the laws of USA would be applicable. The agreement also provides for the jurisdiction of the courts of District Borivali at Mumbai. Dispute have arisen which have to be referred to arbitration. Which court should be invoked for appointment of arbitrator? Supreme Court of India. Which amongst the following would not amount to an arbitration agreement under Section 7 of Arbitration and Conciliation Act 1996? An agreement which required the parties to further consent before making a reference to arbitration. Indian arbitration law is premised upon the Singapore Code. Is this proposition true or false? False. It is based on the model law of the United Nations Commission on International Trade Law. Correct this proposition. International commercial arbitration under Section 2 of the Arbitration and Conciliation Act 1996 is arbitration of any dispute between two parties, both of whom are resident abroad. A होगा इसका आंसर। It is arbitration of commercial dispute between two parties, at least one of which is either a foreign national or resident or incorporated abroad, or whose central management and control is exercised from abroad or is a foreign government. Next, since arbitration is a process of adjudication by private person, the legislature has laid down the scope of judicial intervention in arbitration proceeding. Which of this is true? C होगा आंसर। Judicial intervention in domestic arbitration is limited under Section 5 of the Arbitration Conciliation Act 1966 to only where it is so provided in the statute. Next, 145. Since under the Indian contract law, any agreement can be either oral or in writing, an agreement to refer dispute to arbitration can also be oral. Is this statement true or false? False. Section 7 of Arbitration and Conciliation Act 1996 mandate that an arbitration agreement must be in writing. Next, 146. An arbitration clause is in contract is not binding since it is in hit by Section 28 of the Indian Contract Act 1872, being an agreement that restrain a party from invoking its legal remedy to file a suit. This proposition is untrue since exception 1st and 2 of Section 28 save arbitration agreement from being void. एक्स इशू करता है टू वाई रिटर्न नोटिस डेटेड 24/10/15 calling upon Y to concur in the appointment of a nominated arbitrator and to refer their dispute to such person. Y received the notice on 29/10/2015 but declines to comply. The arbitration agreement is silent as the date of commencement of arbitration proceeding. Pick the correct statement. Arbitration proceeding would be deemed to have commenced on 29/10/15 under Section 21 of the Arbitration Conciliation Act 1996. In accordance with the agreement for a three-member arbitral tribunal, X appoints Mr. A1 as his nominees arbitrator, Y appoints Mr. A2 as his nominee arbitrator, and Mr. A1 and Mr. A2 together agree and appoint Mr. A3 as the third arbitrator, who will act as the presiding arbitrator. Which of these is true? All three arbitrated are expected to act with independence and impartiality, regardless of the party that may have been nominated or appointed them. Complete this proposition. A dispute between landlord and tenant arising from the tenancy is not amendable to arbitration unless it is outside the purview of rent control legislation. Before filing written statement, the defendant, an Indian national, files an application under Section 8 of the Arbitration and Conciliation Act 1996 seeking reference of the dispute with the plaintiff, an Indian company, to arbitration based on arbitration clause in their contract that covers the subject matter of the civil suit. What could you do as a civil judge? Refer the matter to arbitration, leaving the parties to appoint an arbitrator by consent or seek appointment of an arbitrator by approaching the High Court. X Limited terminates its contract with Mr. Y, which contained an arbitration clause. Which of these proposition is wrong? The arbitration clause perish once the contract is terminated. Which of the following dispute would not fall within the definition of a commercial dispute under the Commercial Court Act 2015? A claim for unpaid rent in respect of a residential property. P files a suit in the commercial court, which it filed before the regular civil court would have been barred by virtue of a provision in another statute. Can the commercial court entertain the suit? No. In a suit for recovery of money filed before the commercial court, the specified value is determined on the basis of C answer होगा. An international commercial arbitration concerning commercial dispute of specified value in respect of such an arbitration, an application or appeal under the Arbitration Conciliation Act would lie before the commercial division of the High Court. Parties enter into a written settlement agreement during the process of pre-institution mediation in a commercial dispute. The settlement agreement is signed by the parties and the mediator. What is the status of the settlement? It is treated as an arbitral award on agreement terms. In any case management hearing held under Order 15A of the CPC as applicable to commercial dispute, the court may frame issue in the suit, direct a separate trial of a particular issue, and exclude an issue from consideration. All of the above. इसके लिए ऑर्डर 15 का रोल नंबर 6 देखना है कमर्शियल कोर्ट एक्ट का. When it is the court required to hold the first case management hearing under 15A of the CPC as applicable to commercial dispute within 4 weeks after all parties have filed affidavit of admission or denial of document. What is the maximum period For pre-institution mediation provided under the Commercial Court Act, 5 months. Under Section 35A of the Code of Civil Procedure 1908 as amended by the Commercial Courts Act 2015, compulsory cost in respect of false or vexatious claim or defenses shall be. तो यहाँ पे ऐसा कोई restriction नहीं है. An order allowing execution of a foreign arbitral award is. Neither of the above answer होगा. Which of the following is considered as an important provision in enforcing the performance of public or statutory duty? Mandamus, we command. Under which procedural rule can a matter of public importance be raised in Lok Sabha? Calling attention procedure. Which judgment of the Supreme Court in 1992 upheld OBC reservation while separating the creamy layer? Indira Sahni case of 1980. Which of the following is not a role of University Grant Commission to set up new colleges and universities? Two Ranganath Mishra Commission was constituted to look into the issue of religious and linguistic minorities of India. How many women judges have been appointed to the Supreme Court of India till 1/1/2022? 11. Who was the first Attorney General of India? MC Sitalwad. What is the total sanctioned strength of judges permanent plus additional at the Delhi High Court? 45. Which Chief Justice of India had the shortest tenure? Justice K.N. Singh, Kamal Nath Singh. The committee is constituted in the year 2000 to look into the reforms in criminal justice system in India was headed by Justice V.S. Malimath, who is the current president of the National Consumer Dispute Judicial Commission, R.K. Agrawal. The expression burning the candle at both hand means. इंग्लिश के क्वेश्चन हैं वो स्टार्ट हो गए हैं अब यहाँ पे देख लेते हैं आंसर. एग्जॉस्टिंग वन सेल्फ वाई वर्किंग हार्ड. आई विल रिटर्न a month. I stayed in Delhi a week. I have not met her. September. तो क्या सीक्वेंस यहाँ पे फॉलो होगा? I will return within a month. I stayed in Delhi for a week and I have not met her since September. I was enlisted to buy into in. क्या आएगा यहाँ पे? यहाँ पे आएगा I was enlisted in the army. The matter dispensed with the service of the staff. Hard work is indispensable to success. The counsel to the client's request. तो यहाँ पे क्या आएगा 177 में? B आएगा यहाँ पे. The words by the teacher from the Gita made profound sense. A leopard was in the village and तो यहाँ पे पूछा है कि क्या आंसर होगा. द वर्ड्स साइटेड गीता में साइटेड है एंड लेपर्ड है उसके लिए क्या आएगा? लेपर्ड के लिए आएगा साइटेड. ए आंसर होगा. हार्ड वर्क precedes good result. The proceeds from the event will go towards charity and the group now proceeds onwards for the mission. The cattle 180 की बात कर रहे हैं तो कैटल के लिए प्लूरल लेंगे. आर आएगा. द कैटल आर ग्रेजिंग इन द फील्ड. द jury is now complete and the 50,000 rupees is not a bad salary. The High Court set aside the decree of the lower court. After appointment, she immediately set about organizing her department, and these seats are set apart for women. Neither the groom nor the bride. क्या आएगा यहाँ पे 182 के में? Wants a formal reception. The state of the student's academic achievement is improving and the law school held its convocation. ए आएगा यहाँ पे. Its convocation outside this year. The head coach is the person who is wearing a cap. तो ये दो तो एलिमिनेट हो गए. My teacher is the only person whose face I recognize. It is clear to whom the credit should go. A आएगा. 184 choose the correct spelling. 184 के में है proprietary. The unruly remonstrance will not change the law that has been passed. Antonym of remonstrance. Acceptance. He said to us, "Are you going away today?" So reported speech में कैसे लिखेंगे इसको? He inquired of us whether we were going away that day. A little help with the notes that I gave to my friend made him an albatross around my neck. A burden that one cannot get rid of. The fact that the toys literally prefigure the world of adult functions obviously cannot but prepare the child to accept them all by constituting for him even before he can think about it. The alibi or nature which has at all time created soldier, postman, and vespers. So, with reference to the above quotation, prefigure means यहाँ पे जो आंसर है वो होगा टू इमेजिन बिफोर हेड. हाउ मैनी स्टेट्स and how many union territories are listed in the first schedule of the Constitution of India? 20 in state हैं, 28 and 8 union territory हैं. The Constitution Bench judgment of the Supreme Court in L. Chandra Kumar versus Union of India is a landmark decision. 1997 3 Supreme Court SSC to SEC and 261 case is a landmark decision on the issue of power of judicial review of the High Court, and Supreme Court is part of basic structure of Constitution. How many languages are included in the 8th schedule of the Constitution of India? 22 language. Where was the Constitution of India adopted? The Constituent Assembly 26 November 1949. How many fundamental duties are listed? 11 फंडामेंटल ड्यूटीज हैं. क्या होने में? विच आर्टिकल ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया कंटेन्स प्रोविजन रिगार्डिंग इक्वल जस्टिस एंड फ्री लीगल एड? 39A. Which article of the Constitution of India prescribes that a person who voluntarily acquired the citizenship of a foreign state shall not be a citizen of India? Article No. In which judgment did the Supreme Court in India uphold the freedom of speech and expression through medium of internet enjoys constitutional protection under Article 19(a)? Anuradha Bhasin versus Union of India 2020. Which articles of the Constitution of India provide for exemption of property and income of a state from union taxation? Article 289. Which article of the Constitution of India empower the President to appoint an acting Chief Justice of High Court? Article 223. Which article of the Constitution of India provide for the function of Public Service Commission? Article 320. Which article of the Constitution of India specify the original jurisdiction of the Supreme Court of India? ओरिजिनल जुरिडिक्शन 131. सारे आर्टिकल हैं, ये इंपॉर्टेंट है कॉन्स्टिट्यूशन के, रिपीट होते रहते हैं. सो कीप वॉचिंग एंड कीप शेयरिंग. नेक्स्ट वीडियो में हम कोई दूसरे स्टेट का लेंगे जुडिशरी के क्वेश्चंस. तो ये क्वेश्चंस आप करते जाइए और अपने आप आपकी कमांड है वो बनती जाएगी. सो थैंक यू फॉर वॉचिंग.